Good morning, good afternoon, our dear friends, colleagues, and members of the European branch of the Chartered Institute of Arbitrators. This is our annual conference, our very first one, which is virtual. It is, as you may see from the top left of your screen, being recorded. And we have a lot to cover, although it's reduced format compared with the previous editions, 2 hours. We have a lot to cover, and we have a great panel of speakers uh, who will um, who will cover our topic today. What a year! Exceptional in all senses of the term. If we look back at last year precisely, well, we were supposed to have our annual conference on the Singapore Convention in Venice. Of course, we had to cancel it, and still we decided to move forward. We organized what was probably one of the first major AGM, at least in Europe, and at least within the arbitration community, um, uh, in a virtual format. And eventually we bounded. We bounded, and that's what I think matters. This is what this also annual conference is about. We It's not that we remain connected. I think this is a word that we say with you are on mute or you're not on mute every single second. I think it's beyond being connected. It's I think also it's about caring, keeping in touch in the real sense of the term again. And it's also about two members receiving news, valuable info, and help from the CIArb. And I'm thinking, for example, about the CIArb um, guidelines, remote pandemic guidelines, which was very early released in April 2020, exactly when we were the first one to organize a virtual general meeting. Uh, and at precisely at that time, we also deployed the new CIArb strategic goals for 2021, based fundamentally on equality, diversity, and inclusion. Uh, and I do want to stress, because this is often a question, especially in days of Brexit, that I am asked about. There is something about the UK culture, perhaps like the US one, the French one, and some others, that makes it universal. And to some extent, although the European branch is rooted also in London, it is meant to be universal, and it has very high profile and legitimate ambitions to make us all gathered. The European branch precisely has remained strong at the level of the figures. We are amongst the most populated branches within this CIArb network, and when we have the support we need from the London headquarters, we are still capable of deploying a very large offerings of trainings. We have organized events in Paris, Vilnius, perhaps soon in Warsaw. We went on, like many others, I think many other institutions. And with our friends from CMS and the kind hospitality of the UK Embassy in Vienna, we managed to hold a virtual reception a few weeks ago. We, of course, expanded, as you may know, in Spain and Russia with the creation of two new chapters in those countries. And that shows the vitality of our branch. I said it was an exceptional year because we coped, and I think rather remarkably well, within the arbitration community and like many arbitration practitioners. But I do not forget that these were very difficult times for many of us, and they remain so. I think at this stage, like many people, including myself, we lost people we cherished. Sometimes because of the pandemics and sometimes unrelatedly. But regardless of the causes, it has been difficult times to mourn those people dear to our heart. I do think of the Duke of Edinburgh, a gentleman indeed, whose passing has to be done in a very close manner. And I'm thinking within our arbitration community of Emmanuel Gaillard, um, whom I think we all very much appreciated. Emmanuel Gaillard was precisely someone who organized a major event on immunities, which is the topic of our annual conference. And I wanted also to pay a tribute to him today. The conference is a unique one, as you may know today, because it tackles a topic that is not often touched upon. And for that, we have an amazing panel with speakers who will give us their respective views, the academic one, the state public one, and the private practice one. And I think this is a very rich panel, which we all look forward to hearing from. Before I leave the floor to them, I would like to pass on to Mitian and Philip, who will introduce the speakers and also organize the Q&A after the roundtable. Mitian Sandahar is Managing Director with Equitas Consulting. He is dual qualified, both as a legal and construction expert. He has extensive experience in international arbitration and dispute boards. He has acted as quantum and delay expert witness in Europe, Turkey, Russia, and the CIS and Africa and the Middle East. He's an esteemed member of the CIArb. He will be introducing our speakers and moderators. Philip Landolt practices international arbitration law at the Geneva law firm Landolt and Koch, and he's a part-time lecturer at the Faculty of Law at the University of Geneva. He is the honorary treasurer of the CIArb European branch, and he will be framing the Q&A after the panel. Mitian, the floor is yours. Thank you very much.
Thank you very much, Jill, for the very kind introduction. And also given me this honor to introduce the esteemed colleagues we are having to speak in this year's annual conference. To start with, we have Cindy Rayo Zapata. She is dual qualified in law and international relations, and she holds an LLM degree in international law. Currently, Cindy holds the General Director position of International Trade for Services and Investment at the Ministry of Economy in Mexico. Her practice focuses on investor-state arbitrations and international trade. She has acted as counsel and represented Mexico in numerous investment treaty arbitrations under NAFTA, ICSID, and UNCITRAL. We have Professor Lucas Misteris, who is a Clive M. Schmithoff Professor of Transnational Commercial Law and Arbitration at Queen Mary University of London. He has published more than 60 articles and 13 books. His practice involves international arbitration, unification of private law, and commercial and civil law reform in the Central and Eastern Europe. Lucas has involved in numerous arbitrations under the rules of ICC, LCIA, ICSID, and so on. Stephen Hayes is an English solicitor based in London office of Cobre & Kim International Law Firm. He's highly experienced in the enforcement of high-value arbitration awards against sovereign states As such, he has involved in multi-billion-dollar enforcement of multi-billion-dollar awards in various jurisdictions. He also assists clients with asset recovery in numerous jurisdictions. And today we have our colleagues, moderators, Ms. Burcu Osmanoğlu. She's a Turkish lawyer by background and partner at Osmanoğlu Law Firm in Istanbul. She's the current honorary secretary of the CIArb European branch. Her practice involves international arbitration and contract law. Last but not least, we have Jacopo Monacci Naldini, an Italian lawyer based in Florence, Italy. He has more than 20 years experience on international contracts and disputes within the energy and construction sectors. He's the current vice chair of the European branch of CIArb. Cindy, Burcu, and Lucas, the floor is yours. Thank you.
Thank you very much for your kind introduction, Metehan. I am extremely pleased to co-moderate this unique roundtable discussion with such distinguished speakers. Before we start, I would like to remind the audience that if you have any questions, please feel free to post them in the Q&A section, and we will have about 30 minutes at the end to cover these. You are also more than welcome to engage with the event using the chat button. Without further ado, we will begin our first question. Law, diplomacy, and sovereign immunity. What does it mean and where does it come from? Cindy, can we start with you, please?
Sure, thank you so much. First, I would like to thank you to the Charter Institute of Arbitrators European branch for your kind invitation and for having me today. In answering this question, I would like to briefly introduce that the term immunity is familiar to all who study and practice international law. And this word is generally associated with the concept of diplomatic immunity. And that is the protection that is granted to certain representatives of a state when acting in the territory of another state. And however, sovereign immunity implies that the states cannot be judged or sued before the courts of other states, which means that a state protects itself and its property from the jurisdiction of the courts of another state. And taking into consideration the doctrine, the immunity of the state is a rule of the international law that facilitates the performance of public functions by the state and its representatives by preventing from being judged or prosecuted before foreign courts. And that prerogative implies that the countries cannot be tried before the courts of other states. And the general rule under international law is that the states enjoy jurisdictional immunity before the courts of other states, and they are subject to certain exceptions. And now, although it is indisputable that the immunity from jurisdiction is part of international law, the domestic law or practice of countries has been fundamental to define its scope. And as such, it is understandable that there are differences in the way in which each state gives life to the figure to international law in its domestic legal system. For example, the U.S. Foreign Sovereign Act is a federal statute that reflects international law rules about the immunity of a state in the courts of other states. And the U.S. Foreign Sovereign Immunity Act contains several enumerated exceptions. If a case falls within one of those exceptions, the FSIA permit that a state being sued as if they were a private entity. So state immunity is based on the principle of equality between states and mutual recognition of their sovereignty, and originally based in international custom and courtesy. And the state immunity now reflects more than that simple courtesy and constitute a principle of international law. And the sovereign states benefit from immunity of jurisdiction or from immunity against enforcement of judicial decisions or arbitral awards. This is the term generally known as immunity from execution. And in general, term immunity from jurisdiction implies, for example, that a court will be prevented from considering claims against a particular state. And the immunity from execution prevents courts of the former state from imposing measures of seizing the property of another state. And state immunity, however, is not absolute and can thus be waived under specific circumstances. And I'm going to give you some examples. When a state agrees to submit a dispute to arbitration, its immunity from jurisdiction is automatically waived. And this implicit waiver of immunity from jurisdiction is widely recognized by international and national law, and as can be seen, for example, in Article 17 of the United Nations Convention on Jurisdictional Immunities of States. And this convention establishes that if a state engages in commercial transactions with a foreign natural or juridical person, the state cannot invoke immunity from the jurisdiction in a proceeding that arises out of a commercial transaction. And another example of this in the New York Convention on the Recognition and Enforcement of Foreign Arbitration Awards and the ICSID Convention, for example, as contracting states of these instruments, states has waived its sovereign immunity with respect to the recognition and enforcement of arbitral awards under this convention. So I will stop here and turn back to you. Thank you.
Thank you. Thank you very much indeed, Cindy, for this most useful overview. And Lucas, can we please hear your thoughts on this too, please?
Yes, thank you. And I'm also delighted to be here. And I have to say that Cindy has made an excellent introduction to the topic. I just wanted to give a slightly different stance to the concept of immunity, both for, which has two directions, both making perhaps a nuanced clarification to people who might not have much experience with immunity, but also give a slightly different perspective. I agree that immunity is effectively based on the concept of equality of states, and therefore no states voluntarily will be involuntarily be submitting to the jurisdiction of another state. And a lot of that comes perhaps from the theory of statutes in the Middle Ages, perhaps 1500s, 1400s, and we have consistently a concept of immunity from that point over. However, although that is an international relations and an international concept, my critique would be that the international community, although it has developed a number of documents, including the 2004 UN Convention that Cindy referred to, and none of these international instruments, there's a European Immunities Convention, there's a UN Immunities Convention, none of them have received enough support by way of ratification. So therefore, the topic remains largely regulated within domestic law. And then within domestic law, I see that there are two different trends. I see the more civilian trend where immunity will be regulated as part of the Code of Civil Procedure, for example, where we have jurisdictional immunities. And then you have the more common law model where you have a specific Sovereign Immunities Act, the example of the UK, the US, and of course, and others. And these texts tend to be much more detailed because they build in much more sort of sort of regulation in that specific act. While, for example, in this classical civil law context, you might get one provision in the civil code, and that's all you get. But in terms of arbitration instruments, the ICSID convention, of course, specifically refers to immunity. And having said that, I mean, these are all immunity, sovereign immunity in the broader sense. But we have perhaps to look also at immunity from a diplomatic side. And there are 2 points to be made. First, in addition to traditional immunity, we have the concept of diplomatic immunity. The fact, for example, that a diplomat who represents a state gets sort of the full immunity from being sued for anything that is done in discharge of his or her duty. And is a running joke in London that one of the largest debtors to the City of London traffic wardens is the US Embassy, because a lot of parking tickets are given to cars of people who are a part of the mission of the US mission in the UK, but none of them is paying because they're pleading diplomatic immunity. That's the very soft diplomatic immunity, not particularly dangerous. No one likes to pay traffic tickets. But there's, of course, other sides of that when, for example, there's a running story in the UK where the allegation is that a wife of a US diplomat who may have been also a diplomat or part of a secret services has run over a younger boy who's, I think, 18 or 19. And again, whether diplomatic immunity extends there. So that's sort of another side of immunity that is not the topic of today. But I want to make very much and emphasize the point of the delegation of the regulation of immunity to a domestic law statute rather than international, and that is because of the point that CD made, that there's not enough clarity, or there's no willingness as to whether one would subscribe to an absolute immunity or some other sort of immunity.
Okay, thanks, Lucas. If I may go ahead with a second question, and still I would say on general principles applicable to state immunity. This topic clearly interferes with public international law and private international law. So I guess we would like to know your view on the following question. Public international law versus private international law. Do they converge somehow on this particular topic? Lucas, please.
Thanks, Jacopo. Before I speak of convergence, I would perhaps suggest that in the majority of cases, for the average lawyer, sovereign immunity would be a matter of private international law rather than a matter of public international law. Public international law is the origin, is the principles, but in the majority of instances, people will encounter in legal practice, whether it's in Milan or in Athens or in Istanbul or in Mexico City or in London, it would be a matter of private international law. Can I sue somebody and can I enforce against assets of somebody? And ultimately, the sovereign immunity defense, as it would come, in these cases, would be a matter of private international law. We need to see which legal system establishes that barrier to the jurisdiction or that barrier to the enforcement, and in most cases would be sort of seen as a classical private international law question. Now, private international law questions are not regulations are not particularly creative in this aspect. I think they both revolve about these more sort of basic questions we have seen. Whom can I sue and under what circumstances I may not be able to sue that person, and against what assets I may enforce, against which party I may enforce. So in that sense, we see the basic concept of public international law, which develops from the 1500s through the modern system, effectively underpinning the private international law conception. And the convergence, in my perspective, of private international law and public international law in this matter came very much as a matter of the 19th century, and perhaps the very famous Italian scholar Mancini. I think Mancini has really brought that blend of public and private international law, and that's why for some people, in the naked eye, it's not distinguishable whether we are talking about public international law or private international law. From the practicalities, from the modalities, what we do is an entirely conflict of laws, public international law exercise, irrespective of whether the origin might have been embedded in the public international law. So when an Italian court or an English court or a Mexican court or a Turkish court looks at sovereign immunity, it would not look at it because of an international treaty, but because of its domestic law and another domestic law that might come into play that warrants that sovereign immunity. With perhaps one exception, if one looks at the ICSID Convention, the ICSID Convention embeds this sovereign immunity very clearly, and while it allows, it mandates as a matter of public international law that every ICSID award has to be recognized as if it was a court of final instance, a decision of a court of final instance in every member state of ICSID. It doesn't extend that in terms of enforcement, because it makes the distinction between enforcement from jurisdiction and enforcement from execution.
Thank you, Lucas. That has been very enlightening. And so I wonder if Stefan, do you have your view? Could you elaborate further on this topic, please? You are on mute.
The first one to fall for that. So thanks, Jacopo, and thanks to the Institute for inviting me to participate in this seminar. And I'm going to, hopefully not too much to the dismay of your members, provide a quick historical perspective on this topic from an English law perspective.
Yes.
And how public and private international law in England converged in the late 1970s. And as we know by then, many states had long since adopted the restrictive theory of state immunity, but the UK was lagging behind, and its courts continued to apply the absolute theory of immunity, although dissenting opinions had started to appear. But this all changed in 1977, when our Court of Appeal decided the case of Trentex Trading Corporation against the Central Bank of Nigeria, in which it formally adopted the prevailing international rule of restrictive immunity into English law. Then the following year, 1978, our Parliament enacted our State Immunity Act, which of course encodes the restrictive approach. In the Trentex case, the Central Bank of Nigeria had issued a letter of credit in relation to a contract for the supply of cement, ordered by the government of Nigeria and destined to be used in the construction of government barracks. The government had ended up with a huge oversupply of concrete and was cancelling contracts left, right, and centre. So the case raised important questions as to the applicability of immunity rules to a central bank, including whether or not the central bank was an emanation of the state, and whether or not the underlying transaction was a commercial transaction, and so exempt from any adjudicative immunity. We'll be looking at those topics later in the programme. But the prior question examined in Trentex was whether or not English law in 1977 reflected the modern international law of restrictive immunity. And our court considered two schools of thought on the subject. The first was the doctrine of incorporation, in essence, that the rules of international law are automatically incorporated into English law unless they are in conflict with an act of parliament. The alternative is the doctrine of transformation, which holds that the rules of international law only form part of English law once they are adopted by an act of parliament, decisions of senior courts, or long-established custom. And the Court of Appeal decided it was the former. Accordingly, that the doctrine of binding precedent did not apply when it comes to questions of international law. The Court of Appeal was free to apply whatever it thought the modern rules of international law were at the time. This turned out to be bad news for the Central Bank of Nigeria. It was found to be subject to adjudicative jurisdiction for Trentex's claim. The State Immunity Act now codifies the UK's immunity law, and subsequent House of Lords authority has made clear that the Act should be construed against the background of those principles of public international law as are generally recognised by the family of nations. And the leading English cases on the topics that we cover later in the programme often contain a survey of the laws and cases from other nations that cover similar ground. So that's my little history lesson on this topic, on how public and private international law converged in the UK in the late 1970s.
Thank you very much. Busu, maybe you can go ahead with some other questions.
Absolutely, thank you. So moving to our next question, is the issue differently tackled in investment and commercial arbitrations? Lucas?
If I may, again, I would rather rephrase the question a bit, because I think to see investment arbitration as a single model is perhaps inaccurate, in the sense that the classical, I mean, one of the issues of investment arbitration is that the consent to arbitration is given not in a classical arbitration agreement, but is given in a bilateral investment treaty or a domestic law or a multilateral investment treaty. So in that sense, we do have a difference between commercial law and commercial arbitration and investment arbitration. But within the investment arbitration sphere, we have arbitrations which are held under the auspices of the ICSID Convention and fall completely under the ICSID Convention. But we also have a lot of investment cases which are dealt with as commercial arbitration cases, because they're under, for example, the Stockholm Chamber of Commerce rules or ICC or arbitral rules. In these cases, although of course we have public international law applied and an assessment of a treaty breach, a lot of the practical aspects of the arbitration look very much like a classical commercial arbitration, like an ICC or an LCIA arbitration. And when it comes to the challenges of the award has the life of a normal commercial award and not the life of the ICSID award. So the ICSID Convention elevates that award to this sort of already no further remedies apart from the ICSID annulment proceeding. And once it has been rendered a public international law obligation for all states to recognize it and in some circumstances to enforce it. While a commercial award will be reviewed at the seat of arbitration and can also be reviewed if enforcement is resisted at the place where the award was made. So in that sense, in the pure investment arbitration, which is ICSID, the interference, if you wish, of sovereign immunity is very regulated in Articles 54 and 55 of the ICSID Convention. And then the test that will have to be had is whether there has been any waiver of immunity from jurisdiction and a waiver of immunity from execution. And ultimately, the enforcement would happen through the ICSID built-in mechanism, which in many respects involves the country director responsible for that state. And that's why we have a very high degree of compliance. In commercial arbitration, we also have a very high degree of compliance, but we do have the possibility for an unsuccessful state-owned entity or state party to try to resist enforcement at two different stages. And again, there's a matter of strategy, whether you challenge the award twice or you challenge the award once. I have written, for example, and I know it's a bit controversial, that perhaps we should get away from any review at the seat of arbitration, because what it ultimately matters is enforcement, and it's what happens in the enforcement courts, especially given that there is in several jurisdictions a possibility of ignoring the setting aside of an award at the place where it was made, especially if the setting aside of the award is done for very domestic or parochial reasons. But I wonder whether sovereign immunity would be one of these reasons that a very sort of progressive enforcement court will see as being too parochial and too domestic, but not necessarily aligned with international standards of immunity. So yes, there are differences, but even within the investment, there are certain cases which move more towards the commercial arbitration context. I would submit.
Thank you so much, Lucas. Cindy, any further thoughts?
Thank you. Well, I think that Lucas has already explained very clearly this differentiation and the similarities, and I totally agree with him. Let me just very briefly try to illustrate this differentiation through the ICSID Convention, and Lucas has already mentioned this. And I think that there is a differentiation under the ICSID Convention and the signing of other international treaties. There is a general recognition that as a contracting state of the ICSID Convention, and by agreeing to submit a dispute with an investor to arbitration that is governed by the ICSID Convention, the states have waived its sovereign immunity with respect to the recognition and enforcement of arbitral awards that are issued under the ICSID Convention. And under this convention, awards are to be treated as final judgments of a state court pursuant to Article 54 of the convention, rather than as arbitral awards. And this is the first differentiation, I think. At present, I think that the discussion also relies on whether there is an implicit waiver of sovereign immunity if the countries, for example, signed the New York Convention or has signed other international treaties. And for example, in the U.S. courts, the courts has tackled this in a different ways. So the existence of an implied convention, an implied waiver, when states sign international treaties, such as the ICSID Convention and the New York Convention, should be analyzed also in light of the Vienna Convention, which provides that a state may not invoke international laws to avoid an international obligation.
Thank you very much, Cindy. And I believe this takes us to the next question. So what about the difference between immunity from jurisdiction and from execution? The great divide, or is it, Lucas?
Well, I mean, obviously from what Cindy was saying, and that's a very good segue, this is really the way, that's a very big question. Just sort of by way of introduction, we do understand at the moment immunity to have three dimensions: is immunity from jurisdiction, immunity from execution, perhaps the diplomatic immunity as well. But in the immunity from jurisdiction and immunity from execution, historically they have been dealt as rather watertight categories, different categories, and immunity from jurisdiction can only be waived by either an express waiver or a waiver that is given in a treaty or in domestic law. And now the immunity from execution, however, is a much sort of bigger sort of ball game. And Cindy is right in making the comment that historically the view has been taken that, well, if you have waived immunity from jurisdiction, why wouldn't that extend to jurisdiction? Isn't execution isn't enforcement of an award, so the ultimate step in what you have already agreed to go to arbitration? And we've seen that a number of cases, I see, for example, that in the chat, there's a discussion about the UCOR shareholders cases and Russian Federation, where, of course, there's a bigger question there, including the reform of the law in France and Belgium to perhaps accommodate an easier enforcement of these awards. But when it comes to, for example, to looking at Russian Federation, the case I always comes to mind is Franz Sedlmayr and the Russian Federation, and perhaps on the commercial side, the case that comes always to mind is Creighton and Qatar. In Creighton and Qatar, we have a construction contract, and under ICC FIDIC contract, ICC rules, an ICC award, and then Qatar argues sovereign immunity when it comes to execution, both in the courts of the United States and in the courts of France. And the courts of the United States say, well, I mean, yes, immunity from jurisdiction is different from immunity from execution, and therefore we do not enforce the award, the French court said, you agreed to the ICC rules, was part of your waiver of immunity from jurisdiction, and look at what the ICC rules say. The ICC rules say that the parties voluntarily undertake to comply with the award as part of the ICC rules. Therefore, that extends to enforcement. And in the France, Edelmeyer and Russian Federation, the origin of the case is a BIT, the Germany-Russia BIT proceedings taking place in Stockholm. And there we have enforcement actions brought in various different parts of the world, including Sweden and Germany. And in the end of the day, that's a question we're going to be addressing a bit sort of later, and I think Stefan will take the lead on that. Then the question becomes is not whether we can enforce, but whether we can enforce against specific assets, and is, for example, a building formerly owned by the KGB or a cultural institute that receives money from students paying to study Russian language immune. I mean, that has also been discussed recently in a case in Greece, when there was an action to enforce against Germany for reparations from the Second World War. So there is that divide, and we see that jurisdictions can be split perhaps in three. Jurisdictions which are reasonably liberal, reasonable pro-arbitration, that read immunity from execution very, very restrictively, or even accept that immunity from jurisdiction would imply immunity from execution. We have those that accept that division, but they would make some allowances for certain enforcement, and we'll also have the countries that they say these are two different, unless we have an express waiver of immunity from execution, no step will be taken. Therefore, the divide is live and is quite significant.
Thank you, Lucas. Stefan, any further thoughts on this?
Yes. From a UK perspective, the great divide between adjudicative and execution immunities remains present, and really is still a fairly strict divide in the orthodox way that Lucas has described. And our State Immunity Act starts by establishing that a state is immune from the jurisdiction of the court unless one of 10 exceptions applies, and those exceptions cover the familiar grounds such as submission to the jurisdiction, proceedings in relation to commercial transactions, and arbitration. And as to the latter, where the state has agreed in writing to arbitrate, the state is not immune as respects proceedings in the courts of the United Kingdom which relate to the arbitration. And we'll come back to that. Execution immunity is then dealt with in a separate part of the Act, and in a somewhat convoluted section 13 of the Act, injunctions against a state and any process of execution against a state's assets are prohibited. It's then provided that both of those immunities may be waived by the state, providing written consent, but that a written consent merely submitting to the jurisdiction of the courts is not to be regarded as a consent for the purposes of waiving immunity from injunction or executions. So there is the orthodox divide in action. The Act then goes on to provide that process for the enforcement of a judgment or arbitration award may be issued against property of the state in use or intended for use for commercial purposes, and we'll be coming on to that again later. So that's the basic framework. And then I just have a couple of points about how this framework has been applied by the courts. A written waiver must clearly extend beyond adjudication. That is clear from the terms of the Act. So what is generally required is wording that expressly refers to waiver of immunity as to the state's assets or property, or consent to enforcement and execution. Ideally, as many of those words as possible would go into your waiver clause when contracting with the state. You would spell out as laboriously as you can every aspect of immunity that you wish the state to waive. Granularity is good when it comes to immunity waivers. So in Svenska Petroleum in Lithuania, a Court of Appeal case from 2006, Lithuania had irrevocably waived all rights to sovereign immunity. That was held not to be a submission to the jurisdiction of the English court at all. the underlying contract contains an arbitration clause, and the Court of Appeal construed the waiver as simply supporting the agreement to arbitrate. More helpfully, from an enforcement perspective, the Svenska case provides that where a state has agreed to arbitration with a non-UK seat, then an application to recognise the award and for permission to enforce it constitutes a proceeding which relates to arbitration for the purposes of the arbitration exception to immunity. A state subject to a non-UK arbitration award would not be able to claim immunity from UK recognition proceedings, but execution against its assets will be another matter. And then finally, and picking up on one of the topics that Lucas was discussing, the UK has flirted with, but not yet actually embraced, the Creighton and Qatar approach of the French Court of Cassation as to whether arbitral rules, and specifically Article 28(6) of the ICC rules, take effect as consent to execution of assets. In Orascom and Chad from 2008, the High Court spent some time considering the issue and even went so far as to hear expert evidence of French law on the nature of the decision in Creighton. But having decided the outcome of the Orascom case on other grounds, the judge declined to make a finding on whether Article 28 was in fact a consent to execution. And that, as far as I'm aware, is the closest we've come in the UK to a finding along the lines of Creighton and Qatar. So in the UK, I would just close by saying that yes, the Great Divide certainly is still present.
Stephen, thanks. So, Cindy, I would like to expand on a different subject. It is known that states operate on their own and or also through agencies. So could you please update us on the use of agencies or similar entities? Are still a reality in the international investment and trade world?
Yes, thank you. I think that states still plays an important role as subjects of international law. For example, when they signed an international investment treaty or a trade agreement. However, we have seen that new agents have appeared. And for example, the so-called sovereign wealth funds, and I will not enter into the detail because I think that this is a point that will be addressed later. And another type of agents, for example, are the state-owned enterprises, the SOEs. And as the name suggests, the SOEs are enterprises that are part or wholly owned by a sovereign state. And it is therefore likely that such corporations will engage some form of investment protection. So the government control investors, such as the SOEs, and including the sovereign wealth funds, have greatly expanded their international activities in the recent years. For example, in modern free trade agreements such as the CPTPP, the Comprehensive Partnership Trade Agreement, or the USMCA, it was the recent agreement signed between Mexico, US, and Canada. It is recognized that the SOEs can act as vehicles of delegated authority of the party. But those activities shall not be inconsistent with the party's obligation under the provisions of these agreements. So in some jurisdictions, when SOEs engage in commercial activities, immunity is removed and it may be treated as a private entity, and this is very important as a new figure of this kind of agents. So and also it is important to highlight, for example, that the sovereign wealth funds have been recognized to be different from SOEs and are also included in these kind of agreements. For example, in chapters 17 of the CPTPP, it is well established that a sovereign fund means an enterprise owned or controlled through the ownership interest by a party of the treaty, and that serves solely the purpose of an investment fund or an arrangement for asset management. So to conclude, I think that there are new agents that are participating as part and have functions as part of the state. And the main issue under discussion is whether the state acts as subject of international public law, carrying out sovereign acts, or as agents of international trade. We have to take into account this differentiation, and whether the transaction is a sovereign or commercial act. And this is also related with the restrictive theory of sovereign immunity, which focuses on the nature of the transaction and not of the structure of the foreign entity. And I will leave it there.
Thank you. That's very clear. On this topic, I would like to know if Lucas has something to add. And I would also ask if is there a particular alert to understand if for a party, if the counterparty who signs an arbitral agreement is entitled to enter into that agreement. Thank you.
Thank you, Jacob. I think we have certainly quite a bit of an evolution on this topic. It's very interesting, for example, that when the New York Convention was drafted, sort of 60 years plus ago, I mean, the focus was that trade is conducted by businesses, but it was understood that there might be a couple of jurisdictions where certain trade will be conducted by state-owned enterprises, certain instrumentalities, which of course limit the exposure of the state by sort of a state-owned export-import company, particularly in planned economies. Then from that to sort of a liberalization and going, for example, to cases like SPP in Egypt, where of course SPP, a Hong Kong company investing in Egypt with view of building a resort opposite the Pyramids Plateau, would do that in an agreement with a state-owned agency, an agency or state-owned enterprise of Egypt, being the Egyptian General Organization for Tourism and Hotels. But the fact that on the cover page of this contract, there's a stamp by the Ministry of Tourism which says approved, that contract is attributed ultimately to the Egyptian state, and therefore Egypt can be sued in these proceedings separate from the claim that SPP had against EGOT in ICC proceedings. So we saw that states have had a period of reduction of their activity and a period of reduction of their influence in the world of international investment law and trade. And we saw in that sort of the period when the states retracted from that, exercising that authority, if you wish, that multinational corporations and non-governmental organizations occupied the territory as becoming actors, non-state actors in international investment law and international trade law. And that was actually, if you wish, the flavor of the month, perhaps in 1980s, in the beginning of the century. But in the last 15 years, we see that the states are re-establishing their position, the historical undisputed position of the state as significant agents, but in a creative fashion. The states create sovereign wealth funds. That we have the sort of in the context of we have had privatization, but we have still certain state-owned enterprises that still occupy quite a bit of the business in the various territories. So the role of the state has been evolving as an agent of international investment and trade law. But the fact of the matter is, in many parts of the world, the state is a significant factor of the economy. Look, for example, at China. almost every single investment case with a Chinese party ultimately is a Chinese state-owned company. Very few of them are Chinese private companies that have been involved in that scenario. And there are similar discussions now. We have had cases with a number of sovereign wealth funds. So the states are a very significant factor, an important agent in the world of international investment. And what we see with that business model that states have developed, states are no longer respondents, but in many cases, states are claimants, and therefore take a new role, which is very, very significant.
Good, good. Thank you very much. Okay, so Cindy and Lucas mentioned several times a particular, let's say, vehicle, investment vehicle, which is the sovereign fund of a certain state. Stefan, could you please tell us if are there standard practices concerning sovereign funds operating in the international trade, and to what extent they might be treated as states?
Yeah, so thanks, Jacobo. I'm going to talk a little bit about the difficulties of pursuing sovereign funds, other types of state entities, combination of the state-owned enterprises that Cindy was talking about.
Wonderful, thank you.
And so, yeah, in the UK, we have a definition of a state that excludes separate entities, and separate entities are defined as being distinct from the executive organs of government of the state and capable of suing or being sued. And a separate entity will only benefit from an immunity, as Cindy was saying, if it acts in the exercise of sovereign authority. And similar questions of classification come up in different ways under the laws of many countries. And for example, the Foreign Sovereign Immunities Act includes in its definition of a state an agency or instrumentality of a state, which is defined as a separate legal person, corporate or otherwise, and which is an organ or political subdivision of the state or majority owned by the state. And to take a more internationalist viewpoint, the United Nations Convention on Jurisdictional Immunities of States and Their Property of 2004 includes in its definition of state agencies or instrumentalities of the state or other entities to the extent that they are entitled to perform and are actually performing acts in the exercise of sovereign authority of the state. The UN Convention is not in force, but nevertheless probably represents a notable recent attempt to codify international immunity law. So the question then arises, after you've obtained your award against state X, can you enforce it against the asset you have found when the asset is owned by an entity with its own legal personality separate from the state, whether it be the state's sovereign wealth fund, or a state-owned enterprise, or even its central bank? Under UK law, the position is very challenging for the award creditor. The leading case is a Privy Council decision from 2012, La Générale des Carrières et des Mines against FG Hemispheres Associates, in which the Privy Council refused to permit awards against the Democratic Republic of Congo to be enforced against the assets of a state-owned mining company known as Gécamines. The Privy Council held that the test to distinguish between an organ of the state and a separate entity was as follows. First, where a separate juridical entity has been formed by a state, there is a strong presumption that its separate corporate status should be respected, and that it and the state forming it should not have to bear each other's liabilities. Second, that it would take quite extreme circumstances to displace this presumption. And third, that the presumption may be displaced if in fact the entity, despite its juridical personality, has no separate existence from the state, that the affairs of the state are so closely intertwined and confused that the entity could not be properly regarded for any significant purpose as distinct from the state. And note that any significant purpose appears to be an extremely high barrier. And so applying that test in the Gécamines case, the Privy Council found that state ownership and extensive constitutional control are of little weight in this analysis, being expected features of state-owned enterprises. Of course, the state owns and exerts extensive control over its state-owned enterprises. So what? In the Gécamines case, the state had, as well as exerting a significant level of de facto control, also requisitioned the assets of Gécamines without compensation to fund its war efforts, and directed Gécamines to participate in a state-to-state joint venture with China, a joint venture that Gécamines itself could not have arranged independently of the state. None of this was enough to allow the award creditors to reach Gécamines' assets. This was because Gécamines did itself conduct legitimate business with third parties independently of the state. It maintained its own budget and was taxed independently of the state. So separate juridical capacity combined with any signs of independent life may be enough to defeat creditor attempts to enforce against the assets of a separate entity. In a glimmer of hope for English enforcement lawyers, the Privy Council reviewed 2 decisions of the French Court of Cassation, in which it had held that Congolese and Cameroonian state-owned entities were emanations of the state, and found that those could be analysed as finding that the state-owned enterprises had indeed no separate existence from the state. So if you're trying to build a case in a common law court that a separate entity should be treated as part of the state, you may need to look at the Gécamines case to see what will not be enough, but you should also look at the French cases to see what might be considered enough. But back to the original question, should a sovereign fund be treated as a state? We see that we start off with a consideration first of its juridical status and constitution to see whether it should be categorized as an instrumentality of the state or alternatively a separate entity. We may find that the fund is structured so that its assets are legally owned by the state central bank, in which case we may have a further problem. The UK affords absolute immunity from execution to the property of a central bank, no matter in what capacity, sovereign or otherwise, the bank may be acting, and whatever the nature or purpose of the assets. This is a stronger position than in some other states, including the United States, Canada, and Australia, which variously impose conditions on immunity from execution of central bank assets, that the assets be held for the central bank's own account, and or that the property not be in use for commercial purposes. But the UN convention that I mentioned earlier mirrors the UK position of absolute immunity for central bank assets, so the UK is not a complete outlier here. And then finally, if you have established that your fund is an emanation of the state and is not entitled to absolute immunity through central bank ownership, there may be a final sting in the tail, whether or not the assets of the fund are attachable as in use for commercial purposes. And I'll come on to that a little bit later.
Thank you, Stefan. So I understand that it's not an easy task to understand to what extent a sovereign fund can be treated as a state, or if the fund enjoys sovereign immunity. Cindy, I wonder if you wish to add something from your perspective, and I would like also to ask if, according to your experience, a party dealing with a sovereign fund can ask for a kind of declaration to declare, to explain if the fund can be subject to sovereign immunity.
Yes, thank you. I would like to address these points from the perspective of the international free trade agreements or the international investment treaties. And as I mentioned previously, in the CPTPP, there is a consideration and the inclusion of the sovereign wealth funds in international treaties. And under these treaties, we consider that they should not be treated as state agents, since they don't, those entities don't have the purpose of acting on behalf of a public authority, since they are created with a specific purpose to act as investment funds. So saying that and agreeing that this, if we agree that from the international free trade agreements perspective, we don't, these kind of entities does not pursue public objectives as representatives of a state. And also in the CPTPP and the USMCA, there is there is a provision in one of the annexes of these agreements referring that in the event of a state participates assuming control of a financial institution through a sovereign fund, this will be subject to the condition that it does not exercise any authority function. So I think that this is the main differentiation, and in conclusion, from this perspective, I think that the sovereign funds should not be treated as state agents.
Okay, that's clear. Thank you very much. Okay, Cindy, if we may move to a slightly different topic on waiver of immunity, which is, as we know, a very debated topic. As far as I know, there are two positions: a restrictive approach and a so-called absolute approach. Can you tell us which is the trend on this particular distinction?
Yes, thank you. Regardless of the approach that a state may take, there appears to exist a general consensus in the sense that a national court can exercise jurisdiction over a foreign state if this state waives its immunity. And in this regard, it does not matter if a state follows the absolute immunity approach or if it has joined to the restrictive doctrine. I think that in both cases, states are able to waive immunity through different ways. The problem is how and to what extent sovereign immunity may be waived. If we recognize that the UN Convention on Jurisdictional Immunities of States reflects the existing rules of customary international law, we may find that the national court may consider that immunity has been waived in the following cases. And I'm going to give you some examples. For example, when the foreign state expressly consents to the exercise of jurisdiction by the courts of the forum. And in this case, consent is clearly expressed and not inferred from acts or behaviors of the foreign state. And it is not possible to consider that a state waives immunity just because it accepts the application of the law of another state or to a contract, or because it has concluded an arbitration agreement with that individual. So, and in this regard, the concept may be expressed in different ways. For example, by entering into a treaty with a state in which the state accepts the exercise of jurisdiction by the courts of the forum regarding one or more types of litigation matters. And in any case, what is important to stress is that international law does not prevent the state from establishing more demanding rules regarding the waiver of immunity from jurisdiction. And we may also find that a national court may consider that immunity on jurisdiction has been waived, and this is another example, when a state participates in a process before the courts of another state, either by initiating the process or by intervening in it, or by performing any act in relation to the merits of the case. So in conclusion, theoretically speaking, states have gradually shifted from the absolute to the restrictive approach. And restrictive immunity rests on the distinction between the commercial activities and the sovereign activities. However, in practical terms, state immunity is governed by the law of the forum. And for example, in many jurisdictions, if a party obtains an award from a signatory state, for example, of the New York Convention or the EC Convention, and the award was rendered in the territory of a signatory state, a state may not refuse enforcement in this jurisdiction on a sovereign immunity basis. So, in conclusion, the restrictive immunity rests on the specific forum of the governing law of the place where the execution will take place.
Thank you, Cindy. Lucas, do you agree with this view, or maybe you have something?
Cindy has presented a very accurate picture. I think the point I want to make is perhaps emphasize that in terms of jurisdictional immunity, if it has been waived, there's no ifs, no buts, to use an expression that politicians use very often. And not only that, but we've seen a number of international instruments repeatedly arguing that a state cannot use its own law, its own domestic, to escape from an arbitration to which it has agreed. I think that's a very clear statement. We have it in the European Convention, for example, a very clear statement. We have a similar statement also in the Swiss law and many other places. What I think the restrictive absolute immunity concept comes more is in the context of enforcement, and I think we have. I mean, I don't personally use the term restrictive in my writing. I use the term qualified immunity. So I like to use either absolute or qualified. And I think as states, and it's been a broader theme, reassess the position in international law in a positive, not in a negative way, it's inevitable that you see in some more respects, and I will come back to that perhaps in a couple of minutes, we have, generally speaking, a more absolute immunity. And with a couple of states perhaps being a bit more, less consistent, if you wish, in their approach. So the qualified or restrictive immunity, in my view, is particularly pertinent in Europe. I cannot speak for Latin America, for example, but most of the European jurisdictions, France, Switzerland, Sweden, the UK, accept this qualified immunity approach, or have accepted it in a number of cases. While you have in some Asian parts, for example, particularly China, Hong Kong, FT Hemisphere is a case that has been mentioned, and move more towards the absolute immunity. And I think in the US, historically, there has been quite a bit of an absolute immunity concept when it comes to enforcement, but with a couple of caveats of diplomatic nature. For example, the US would, contrary to what the New York Convention suggests, would be, the US courts would accept a lack of personal jurisdiction plea from a state or a state-owned enterprise, and not to move with the enforcement, or a form of non-convenience, which is the most classical way of that having been framed. So in several cases where state-owned companies or states are involved, although the US seemed to be pro-arbitration and pro-enforcement, they would use that aspect of immunity which edges more absolute. So it's a bit of a mixed direction, and I'm sure Stefan might have also comments when he speaks. But I think Europe perhaps stands out as not endorsing as such absolute immunity at this stage. Whether this would change, that's a good question, because even in countries where we have seen a bit of increased skepticism towards arbitration, and investment arbitration in particular, if you see, for example, that the German settlement of cases, including Vattenfall, then there's a fear that within European systems, immunity is not absolute, and therefore is better to settle.
Thank you, Lucas. And I think we will go back to this later. Bursu, could you please go ahead with one of your questions?
Thank you. Well, we have, of course, partly covered this, but can we talk a bit more about the exception of commercial assets under the national statutes and its application in practice, Stefan? You are muted.
So, as we've discussed, states are generally no longer immune to adjudicative jurisdiction in respect of proceedings relating to commercial transactions, and their assets are no longer immune to enforcement jurisdiction where they are in use for commercial purposes. And focusing on the enforcement immunity, we see similar formulations of the exception around the world. In the UK, the asset is not immune if it is for the time being in use or intended for use for commercial purposes. In the United States, it's whether the asset is used for a commercial activity in the United States. And the UN Convention uses a negative test whereby it must be established that the property is specifically in use or intended for use by the state for other than governmental non-commercial purposes. So looking at those formulations, one's instinctive reaction might be that certain bank accounts, brokerage accounts holding securities, debts arising from commercial transactions and so on should all be fair game. But as ever, the cases show that the matters are never simple. 3 examples. First, it's probably bad luck if you found the bank account of your state's diplomatic mission. The state uses the account to pay its electricity and phone bills, to pay its gardener and caterers and other contracts for the supply of goods and services. So it's in use for commercial purposes, right? Wrong. A credit standing in a bank account is treated as one indivisible debt. The diplomatic mission may enter some commercial transaction, but it most likely will also use its account for non-commercial governmental objectives, building good relations with the host state, building scientific and cultural links, conducting covert surveillance operations, all that sort of thing. And you can't divide up the mission's account into commercial and non-commercial purposes. It's all immune. That's the English House of Lords case, Alcom and the Republic of Colombia, citing with approval a German Constitutional Court decision to the same effect, the Philippine Republic, and there are also US cases to the same effect. Second, just because assets are being used to generate profits for the state doesn't necessarily mean you are home. And this will please Cindy. You found a sovereign wealth fund's brokerage accounts at an investment bank holding hundreds of millions of dollars of shares, securities, derivatives, and other exotic financial instruments. The securities are being actively traded. Surely they are in use for commercial purposes. Well, maybe not. In AIG in the Republic of Kazakhstan, the English High Court found that the financial assets of the National Fund of Kazakhstan were used for sovereign purposes, as it looked at the overall purpose of the fund, which of course was to provide a hedge against oil price fluctuations to stabilize the national economy and to provide a rainy day fund for future generations. And these are the overall sovereign purposes of most sovereign wealth funds. Thirdly, a debt may have originated from a commercial transaction, but may not now be in use for commercial purposes. A state has acquired a portfolio of debts previously owed by a commercial bank to its commercial creditors. That would seem to be a promising start. But again, no. It is not the origin of the asset that counts, but its use at the time of attempted enforcement. And the scenario I've just described was considered in England in Savas and Raffidain Bank, in which it was held that commercial debts acquired by Iraq were no longer in use for commercial purposes because any proceeds of the debts were destined to be transferred to the Development Fund of Iraq, which manifestly was not a commercial entity. The same applies in the United States. In Connecticut Bank of Commerce and Republic of Congo, the Court of Appeals found that what matters under the FSIA is what the property is used for, not how it was generated or produced. What matters under the statute is not how Congo made its money, but how it spends it. So that's all quite bleak from an enforcement perspective, but let us not lose all hope. The Republic of Chad relied on large World Bank loans to develop its oil reserves. In order to secure repayment of the loans, the revenues from its oil sales were structured through accounts at financial institutions in London, where the funds were divided into accounts to be used for loan repayments and otherwise for transmission back to Chad. In Orascom Telecom Holdings and Chad, the 2008 case, the High Court was satisfied that the funds held in certain of these accounts were in use for a commercial transaction, namely receipt of funds from contracts for the supply of oil, and had not yet acquired any secondary sovereign use. So at least I've finished my summary on this topic with one enforcement success story.
Thank you, Stefan. It's extremely useful. Lucas, would you like to add anything to that?
Yeah, I think Stefan described the matter very accurately, actually, almost forensically, I would say, and the classification of assets is really a sort of textbook quality. What I would like, however, to say is that if we look around the world, is that the exception has been used quite often, and is not not always too difficult to bear fruits. And I would see that, for example, to be largely also the basis of success for Franz Sedlmayr. And it's perhaps interesting to say that Sedlmayr, in this particular case, after this enforcement of an award, which was in his favor for 2.3 million, he managed to collect 10 million from the Russian Federation, and has also created a company which is particularly focusing on asset tracing, and in that way also that classification. So I think the commercial assets exception would work, especially where you are in a qualified immunity scenario, so largely within Europe. But it would not work very easily outside Europe, because a lot of courts would not make the distinction. We would not enter into that debate about assets in order to see whether to enforce or not. It would be often easier to refuse enforcement altogether rather than to engage in that discussion, and of course rattle feathers in this way. But my feeling is that we have seen it used. We've seen it used effectively, and I can see no reason why, again, within Europe, that is not going to be happening more often.
Thank you, Lucas. Jacopo?
Yes, I think it's time now to go for the last question from our side, and then we will have the Q&A session. If I understood well, it is difficult to establish at present a trend concerning the absolute or restrictive or qualified approach on waiver of immunity. So now I wonder if is there a commercial trend in the laws and case law for more protection in favor of the states? Stefan.
Yeah, I mean, I think this is a very difficult question, and one that the answer, yeah, the answer might vary depending on how global the perspective you're looking at, and also the time horizon that you're looking at. And if you focus at different times and on the different geographies, you might come up with a different answer. So I'm going to try and make life easy for myself and sort of focus a little bit on Europe. And we all have seen and understand that over the middle part of the last century, there was a significant move from absolute immunity to restrictive immunity. And that was quite well established probably by the mid-1950s, and certainly by the late 1970s and early 1980s, when a lot of the common law jurisdictions introduced their immunity statutes. And that obviously curtailed the immunities of states very significantly. But then if we ask what has been the situation since then, and in what we might call the more modern world, then we obviously see out, and in the sort of cases that I've been talking about, we see a significant tension between two kind of major public policy concerns that are very important in many states. And the first is the importance of supporting international arbitration, rendering such support through the courts as is necessary to support the effective functioning of the arbitral process and goes with that, of course, the enforcement of arbitral awards. Set against that is the body of immunity rules that grant special privileges to states and which are deemed necessary for reasons of comity and international relations. Viewed over the more recent timeline, I'm not sure I see a trend for more protections necessarily, because I think many courts in many jurisdictions have always been very astute to give effect to immunity laws to their maximum degree, and taking an unscientific approach. When I kind of, having reviewed cases in preparation for this presentation, I perhaps in a little bit in contrast to what Lucas said at the end of his last section, was that generally, the road of immunity law in respect of at least commercial disputes is sort of strewn with a wreckage of failed enforcement cases, at least from a UK perspective. And then, of course, then in the same time zone, over the last several decades, we've had the huge development in investment treaty arbitration that Cindy's been talking about, and the Institute could probably hold an event on its own dedicated to debates over the fairness of investment protection arbitration as between states and investors, and that's a highly political issue. So I might avoid dipping my toe in those murky waters, and Cindy will be perhaps braver than me when she comes on next, and we'll see. One slight digression on this topic, and your members will generally be focused on immunity in the commercial and investment protection spheres, but there is another area in which immunity conflicts with important policy issues, and which Lucas touched on with two stories from the UK in his very first topic. And that can be the question of human rights, and immunity statutes drafted in the 1970s must now be construed in an environment where the conception of and importance of human rights has developed significantly. In the UK, we've had cases in the past decade arising from renditions and torture by state actors, where the courts have redefined the boundaries of immunity and the concept of non-justiciable act of state, at least slightly more in favour of the individual. And then on perhaps a less striking subject matter, employment rights, certain provisions in the State Immunity Act giving immunity to claims by all mission employees have been declared incompatible with the European Convention on Human Rights. And that case involved a finding that the relevant immunity in the State Immunity Act was not in fact a part of international law, and so should not have been in the Act in the first place. So there's perhaps a trend in favor of the individual in its dealings with the state. But returning to the commercial sphere, as I said earlier, I tend to perceive that courts continue to be and always have been alive to the importance of immunity rules, and generally are inclined to apply them strictly, whether or not that appears to frustrate the legitimate efforts of award creditors to be paid.
Good. Thank you very much. So Cindy, now we wish to hear from you, which is your position on that. Thanks.
Thank you. Yes, I totally agree with Stefan that the perspective may vary where you were situated in the globe. And the problem lies in the fact that the legal and judicial practice of states in this regard have never been uniform. And as Lucas mentioned, there is still some states that maintains an absolute approach to waiver its immunity. So from these different perspectives, and also from since the 70s, many countries have adopted the special laws on immunity, moving away from an absolute approach. The increase in trade, the investment flows, also has led states to rethink the issue without nothing to preclude from changing their approach. And this without even considering, for example, that some countries such as Mexico, which do not have a specific law on this matter, leaves the analysis of the issue to the courts in a case-by-case basis. So in this regard, for example, although there are many petitions in the different jurisdictions to enforce ISDS awards, we have seen an increase in judicial decisions involving actions to enforce ISDS awards against foreign states. Of course, this increase may be partially explained by the significant growth in investment arbitration claims adjudicated over the past, but the increase may also reflect a change in the position by certain countries towards the ISDS arbitration. And states, it is important to know that states are also rethinking the way investment protection functions. There is an important debate that are looking for an ISDS reform. So saying that, and at this particular moment, we believe that states are cautious and will not change their approach in favor for a more protection. It is important also to know that new agents are emerging, and after all, I think that confidence is the basis of trade and investment, and if that confidence is broken, the negative effects of this may be greater for states than those that they intend to prevent. And I want to finalize citing a professor, Professor Schutter, that explains that, and I'm going to cite textually, allowing plaintiffs to proceed against foreign states and then to withhold from them the fruits of successful litigation through immunity from execution may put them into doubly frustrating position of having been lured into expensive and seemingly successful lawsuits, only to be left with an unenforceable judgment plus legal cost. So I'm gonna leave here, and I think that the perspective and this will evolve, will depending on the if more trade flows and investment flows will be increasing in these last years.
Thank you very much, Cindy. Before passing to the Q&A session, may I ask you if we can draw the conclusion that on this subject matter, on state immunity, waiver of immunity, the debate is still very, very open, and we cannot say that there is a trend that may give an orientation to investors, individuals. Is it open? Completely open? More open, let's say more open than defined. You're on mute, Cindy? Cindy?
Yes. Sorry, could you repeat the last part, please?
Yes, I was wondering if we may draw the conclusion that on this subject matter, the debate is still more open rather than defined, that we cannot say we have an orientation. Maybe we will have an orientation in, let's say, 10-year time, but at present, it is an open issue.
Yes, I definitely agree that it is an open issue, and we have seen an evolving of as I mentioned, an evolving of new agents, of new trends in the interaction between states. So I think that it is open rather than closed. There are new also. There are many ISDS decisions and jurisprudence on this issue. And the debate will continue to be open. I also want to recall or to mention that there is not a clear approach on this issue. The absolute approach and the restrictive approach are stiff into debate. So I think that we should see this in light of this perspective and as an open debate in the near future.
Thank you very much. So Absent possible final remarks from Stefan, Lucas, or Cindy, as you like. Otherwise, we can go ahead with the Q&A session. And Busu, would you like to say something? Lucas, please.
Because I think Stefan and Cindy had addressed that issue recently. I think sovereign immunity is one of these evergreen topics. The difference is that the way we approach the topic has changed, and I think, and this has not been addressed as such, but I think the attitude of states towards ISDS, which has been changing over the last 15 years, has had an impact of how we look at immunity. I mean, immunity in the context of litigation or arbitration has been more or less on a steady flow for many, many years. But there has been a bit more increased attention, and including attention by non-disputing parties, by non-academics, when it came to the issue of ISDS. And that's actually sort of, I wouldn't say it's a time bomb, but effectively is a topic that would have to be addressed. And there was an interesting question that came from the, I think from the chat, about what's happening with the UN Convention, and if there is a consensus emerging, why this text from 2004 hasn't had any more than 22 ratifications. I mean, it's a fairly low uptake, and if one looks at this, obviously, one could argue that the text that has been drafted and came to this final text of 2004 represents a different sort of historical momentum. And I think treaties, if they don't get the right momentum in the beginning, then they don't develop very much. So we really have, I think we have the feeling that even if that will enter into force, it will have some little impact because it will bring perhaps 30 countries, but what happened to 160 others?
Thanks. Busu, would you like to conclude and pass the audience to Philip, probably?
Let's proceed with the Q&A indeed. Philip, over to you.
Thank you, Jacopo. Thank you, Busu. I'm starting my video. I'm sorry it's taken that long. We have a number of questions, and I should launch right into them, given that doubtless they deserve a good deal of attention. But I would be remiss if I were not immediately to thank our contributors for their excellent presentations and for all the valuable information you've provided us today. It falls to Jill, our president, to thank you formally at the end of today's proceedings. The first question, and I'm going to leave it to anybody who wants to answer, is, are all states treated the same for the purposes of benefiting from state immunity? Or is there some subtle tacit jurisdiction applied? Even though, as our contributors have said, the basis of state immunity really is respect for the equality of states. Any instances or notions of some states treated more credibly in regard to their applications for state immunity? Who would like to answer?
You're trying to lure us into the more political side of the debate here, Philip. I mean, I think that's a question that sort of can be said. Do courts consider states like in some ways private actors? There are good ones and bad ones, and I mean, one always sort of likes to think that the answer to that would be no, and that everyone gets treated according to the evidence, and the law is applied equally to everybody. And I think there are some states out there that are in front of the courts of different jurisdictions far more frequently than others. But I think at the same time, the major jurisdictions in which multiple enforcement efforts against certain states are made are sophisticated enough and conscious of the issues enough that they are able to maintain the necessary degree of sort of impartiality and apply their laws consistently, even if they're having to do so multiple times. And when I talk about this, there are obviously some states in South America that have had nationalization programs that have led to waves of litigation against them, and enforcement actions in the States and London and elsewhere by multiple creditors. But ultimately, I think the enforcement lawyer side would say that the state still gets a fair crack of the whip. These states have access to high quality legal advice to fight their corner, and so to that extent, my inclination would be to say that states generally do get a fair shot.
Okay, very good. I should say, would someone else like to add?
I would like to address it briefly. I think at some level, one would think that the politics doesn't find its way in national courts, and given that the judiciary that ultimately makes a decision is very much independent from the executive part of the government that might have a view as to whether a state is worthy of our protection through this exercise of sovereign immunity. But I think what it happens in the end is not whether a state is a bit more credible or not, but whether a state has engaged with the process in an appropriate fashion, and perhaps even with appropriate legal defense. And we see that becoming a bit of an issue in some jurisdictions. And also, I think the other thing we've seen very often is that a number of states, in order to sort of solidify the position and the perception of a national court, have even engaged sort of PR companies that have particularly addressed sort of with a number of press releases which have been drafted for them. So it's a matter of sophistication in the legal representation rather than an attitude of the courts as to whether they would see, let's say, or retain a different than utopia. I don't think it boils down to that as such. Although some of the language of the court, of certain particularly common law courts, could show some sort of an underlying bias, perhaps, if you wish. But I'm not going to go into that case.
No, it's delicate. I should say that insightful question is from our colleague, Amar Ghafour. And here's a question from Miro Prek. The EU certainly has legal personality, it says it does, and I think for many purposes it is treated by states as having legal personality. How is the EU treated in terms of claims of sovereign immunity?
Well, the EU has a personality in the sense that the EU is an international organization, after all. Of course, what we see is that in certain sort of fora, the EU is trying to acquire a de facto, rather than the jure federal state sort of status. For example, if one looks at the representation of the EU in the Working Group 3 of Arbitral, it has the effect that effectively member states of the EU do no longer make contributions to the discussion, but the EU, which is an observer and not a member state, actually speaks for the states, which is a matter of an EU treaty that the EU Commission has assumed that role in investment context. Now, in terms of liability and in terms of immunity as such, of course, as an international organization, the EU has a number of immunities. There's a recent debacle in the UK as to whether EU permanent representatives to the UK deserve diplomatic immunity or not. But leaving that particular sort of post-Brexit sort of issue aside, I think what we know from the EU is that there is a text, a European Union text, which looks at allocating liabilities, and I will argue even immunities as and when a case is brought against a state, member state, and the EU, or the EU on behalf of a state. So there is already that debate that is taking place, and it is an international organization. As we know, it's also a member of the Untitled Chapter Treaty as a regional economic integration organization. But that allocation is happening there, and I think has not been yet tested. It is an argument that Italy brought up when Italy withdrew from the Energy Charter Treaty, that one can sue Italy, can sue the EU, And if the EU finds that ultimately that's a matter for Italy to defend or to pay or to do, that we have a mechanism to deal with that.
Okay, very helpful. Another question from our colleague, Eugenio Zoppis, is in the UCOS enforcement in the UK, the Russian Federation raised issues of sovereign immunity against enforcement on the basis that it had not, in fact, agreed to even sovereign immunity with relation to jurisdiction, in that there was an investment which was not consistent with the Russian constitution, regulations, and law. To what degree is this a real issue in relation to sovereign immunity, and how seriously was it treated?
I think the enforcement of the UCOS awards is and I would assume that even the late Emmanuel Gaillard would agree, is an ongoing saga, in the sense that my personal view was that I had hesitation as to whether the award is correct on a matter of jurisdiction, in the sense that Khodorkovsky and a lot of the UCOS companies were ultimately Russian when they invested, and somehow the shares passed to parties which are foreign, and they could have relied then on the Untitled Chapter treaty. I think the other, of course, aspect for the Russian Federation is the provisional application of the Energy Charter in respect of Russia. Russia had signed but not ratified the treaty, and therefore the treaty was activated only on the basis of the provisional application, which is a rather unique provision to the Energy Charter treaty. So there are a couple of jurisdictional issues, but of course, one of the important aspects is that Russia did participate in the proceedings, of course, challenged jurisdiction, but their decision, and then on the merits they continue to challenge, and then in some respects did also sort of have a level of success. My issue about the saga is that, of course, we do not know. We see that at least in France and Belgium there was a bit of early willingness to go ahead and enforce the award, while in jurisdictions like, for example, the UK, there has been quite a bit of hesitation to do that, and they wait for the outcome of the final parts of the Dutch proceedings. So it's a complex case, but ultimately the award is what it is. Whether that award would ever be enforced, if it took Sedlmayr perhaps 10 years to enforce a $2 million award, when one speaks for a $50 billion award and does the projections, I'm not a statistician, it might well be beyond my lifetime.
Okay.
Yeah, so I was just going to say, just to add to what Lucas said about the UK's attitude, I think the question seems to have a UK focus. I think there was a decision maybe 24 hours ago, or at least within the last couple of days, in which the UK as one of the judges in the High Court has upheld a stay of the or recognition and enforcement proceedings in the UK pending resolution of the challenges in the Netherlands. So if we're going to divine anything from the UK's position, it's that they want to leave as much as possible to the Netherlands to do.
Okay. Yeah. In Stephen's presentation, there was reference to how the courts in the United Kingdom are referring to what other countries are doing in relation to the sovereign immunity, in particular in regard to the Trentex case. You know, this is obviously something that concerns public international law. So there needs to be a consensus of good faith interpretation and application of public international law. But the United States courts are notorious for resisting reference to foreign law in any context. And I was wondering, perhaps Cindy, whether there's any evidence of other courts in other countries taking into account the practice of courts in other countries in relation to sovereign immunity. Mexico, the United States. Perhaps Lucas may have something further to say. Outside of the UK, is there any such engagement with the practice and decisions of other countries' courts?
Yes, Philip, in the case of Mexico, I think that we need to tackle the issue under a case-by-case basis. We don't have, for example, as the US have a foreign sovereign immunity law or act in Mexico, and so we rely too much on the decisions of the U.S. courts, since in the case of Mexico, most of the cases, ISDS cases, the place of arbitration are the Ontario courts, for example, or the U.S. courts. So our practice relies too much on these courts. So, and I would like to, for example, to highlight that, and it's related to one of the questions of the audience about if there is an implied waiver provision of immunity, and for example, in many U.S. courts, try to avoid this kind of perspective, and for example, in the ICSID Convention, as I mentioned, and the New York Convention, there is an implied waiver provision, but in many cases, the U.S. courts, the district courts, have found that the signing of an international treaty does not entails that there is an implied waiver provision of sovereign immunity. So we need to, from the U.S. perspective, and under this Foreign Sovereign Immunity Act, we have to rely on the specific exceptions that are provided in this law, and I think that there is a cases by cases that relies much morely in these exceptions that are in this law, and I just want, for example, to cite a recent case reads that is in the USA, the Rears versus Deutsche Bahn, and in this case, the US, for example, the U.S. District Court found that denied finding a waiver of sovereign immunity when states sign international treaties are not for the enforcement of arbitral awards. So, in conclusion, the differentiation between an implied waiver provision under the New York Convention or the ICSID Convention is not the same when it deals or it is related to another international treaties that are not for the enforcement of arbitral awards.
Okay, thank you. Another question is whether, despite the trend toward what Lucas has termed the qualified approach to sovereign immunity, there's still, if you'd like, virtually a presumption in favor of it, in as much as Lucas said there are three categories of countries who treat waiver of jurisdiction as amounting to waiver of enforcement. The fact alone that waiver of jurisdiction doesn't constitute waiver of immunity in relation to enforcement, doesn't that operate as a sort of presumption against presumption in favor of state immunity? Isn't it right that anybody challenging allegations or assertions of state of immunity is facing an uphill battle?
I think it's fair to say that the presumption would be immunity. Absolutely, that would be the correct sort of presumption to make. And I think every party that needs to bring a case against the state or state-owned enterprise, it has really to think strategically. First, in the legal test, which is largely an objective test as to whether immunity has been waived or can be waived in circumstances. But then also you need to be thinking very carefully as to whether it would be possible to even find assets and be able to enforce against these assets. So you need to do almost a bit of an investigation. Otherwise, you have often the risk of going through a very long process and have nothing in the end. I think people get very enthusiastic about doing that, and I have perhaps to say that the emergence of third-party funding has made parties do the due diligence at an early stage, because you're never going to obtain third-party funding unless you have evidence of that due diligence, and that will be tested in so many ways.
In regard to arbitration in particular, is it possible for a state to withdraw its waiver of immunity to jurisdiction? In other words, you've got agreement to arbitration by a state, and that's going to constitute a waiver of immunity to jurisdiction. Are there any circumstances where a state can go back on that? I mean, ultimately, it overlaps with the question on whether you can go back on an arbitration agreement at all. Plainly, that's in principle impossible, but can anybody think of any exceptions?
No, I think the short answer would be no. I think once waiver has been, once consent has been given, it cannot be revoked, because although consent is a unilateral act, it activates a contract, and then it's reasonable for the other party to rely on your waiver and the consent. So there have been over the years attempts to bypass that. For example, Ecuador passed a constitutional reform that would sort of make invalid any consent to arbitration, any waiver, if it relates to petrochemical industries. There have been many other ways, but we know in the orthodox way, even terminating a BIT is not the end of the waiver, because of the sunset clauses. That the waiver would have a validity for some time. So it's very, very difficult to do that. I think what is possible is to go ahead with the process and then bring appropriate affirmative defenses or challenge the admissibility of claims, but not such a jurisdiction.
Okay, very good. We have very little time left. I would say one last question, and it's quite a straightforward one. What practical advice would you give to a party dealing with a state in an arbitration in view of avoiding entanglement in issues relating to sovereign immunity to jurisdiction and sovereign immunity to enforcement, perhaps at the drafting of the arbitration clause stage or thereafter? Who wants to answer that?
I covered that a little bit in when we were talking about the commercial uses exception, and I think that there are sort of two approaches. One is, I mean, the first thing is you just have to separate out adjudicative submission to jurisdiction and enforcement. You just can't be you shouldn't be attempting to have some overarching submission to a jurisdiction that you think is then going to be applied in different countries around the world for different purposes. And there's sort of, you take the lawyerly approach to this, it would be you would sort of put all the main immunity statutes in jurisdictions that you think you might end up wanting to be active in, sort of read them and make a shopping list of every single item in them that you think might be relevant to enforcement or jurisdiction at some point, and have a long list of things that the state waives its immunity to. That may be overkill to a certain degree, but fundamentally, if you want to have a waiver to if you want to have an effective waiver to enforcement, you have to be talking about property and assets, and either consent to enforcement against them, or just generally waiver of immunity in relation to them. I mean, in some way, the sort of successful waiver clauses have those components to them.
Okay, very helpful. At this stage, I'll thank our panelists again for your very knowledgeable and helpful views, and I'll turn our forum over to our president, Jill Al-Haddad. Thank you.
Thank you very much, Philip. It has been a pleasure listening to you all. I knew or rather I thought I knew things about this passionating topic, and like so many different fields in the law, you become very humble when you basically discover that when you dig into some aspects, it's a new universe that's opening up in your eyes, and there's actually little you know, both and actually from all the perspective we heard, i.e. the academic one, the sort of administrative and historical one, and the private practice one. We even heard some sort of practical tips. I think it was again, as expected, a very interesting topic. I do want to thank very much, of course, Cindy, especially Cindy, for waking up very early in Mexico to be with us, and who we want to free now. Thank you very much to Lucas and Stephen, and obviously to our fantastic moderators, Burcu, Jacopo, Philip, and Mitien. I do wish we can gather next year in person, somewhere nice, perhaps in Venice, perhaps elsewhere. Let's keep and remain hopeful. It's fundamental. Thank you very much, and all the best to you all. Goodbye.